Oh, hello. Thank you, Mr Deputy Speaker. I rise to speak on the cognate debate of two bills which covers biodiscovery, a big rel, and the appointment of a Rehabilitation Commissioner. There are many important elements of the Biodiscovery and Other Legislation Amendment Bill 2019, which includes its incorporation, recognition and legal protection of our First Nations people and its reflection of the international standards of the Nagoya Protocol. The amendment of the Biodiscovery Act 2004 provides obligation for the use of traditional knowledge that will help Queensland's biodiscovery industry remain globally competitive. It will also ensure that the benefits of biodiscovery are shared equitably throughout Queensland, including with First Nations peoples. This is welcomed and essential as part of our journey forward together and the future this creates. Mr Deputy Speaker, however, as outlined in my Statement of Reservation in February this year, there are concerns to be noted. Firstly, through submissions at the public hearing and briefing, as well via the Traditional Knowledge Stakeholder Roundtable, were the questions around a lack of a code of practice. This code has been referred to as an essential document in identifying the appropriate and authorised custodian of the traditional knowledge, the circumstances in which the traditional knowledge obligation applies, and the minimum requirements to fulfil this obligation. Without this code to consider in parallel with this bill, it has been difficult to obtain a more robust understanding of the processes and support for the resolution of these issues. Mr Deputy Speaker, it has also been difficult to identify other appropriate mechanisms that will address potential for delays for important, maybe life-savingly vital access to medical advancement for Queenslanders. This is not something to be taken lightly. Secondly, and given the complexity of the bill, the time to draft the Code of Practice could both restrict the ability of participants to consult fully on complex issues, as well multiple industries may be impacted during this time, including pharmaceuticals, agriculture, nutraceutical and cosmeceutical industries. This in turn can directly impact all Queenslanders. Thirdly, submitters support this bill and its intent, but there is the question around how will the bill be applied in practice. Griffith University researchers and legal counsel raised issues pertaining to the management of traditional knowledge when held by multiple groups. The deferral to a code of practice and guidelines further complicated these issues. It may not be considered standard, appropriate or possible to have documents such as these available when considering all bills. However, in such an important arena that may be instrumental in, for example, curing cancer, dementia or even the COVID-19, it would have given reassurance to all stakeholders, as well those examining this bill, what a complex arena and to have these available. Mr Deputy Speaker, to the second part of this cognate debate, the Environmental Protection and Other Legislation Amendment Bill 2020, which provides for the appointment of a Rehabilitation Commissioner. The bill also clarifies and enhances the residual risk framework to manage risks on sites after an environmental authority for a resource activity has been surrendered. We all need to be confident about the outcomes for rehabilitated mine land. The role of the Commissioner is vital in this, as is the funding and ability to move forward in the rehabilitation of these sites and the benefits this can deliver across Queensland. This includes jobs. We also need to be confident that the strong legislative framework we put in place is informed by stakeholder consultation. A lack of or limited consultation with key industry stakeholders has raised some concerns, and we have heard of some of these earlier. While COVID-19 may account for limited opportunity for submitters to provide comment on the draft bill, stakeholder input is critically important. Indeed, best practice policy and legislative development happens when stakeholder consultation is undertaken on all aspects of a bill. Stakeholders further highlighted that industry is more than willing to resolve outstanding issues in line with expectations through this consultation. Both bills in this cognate are admirable and essential, though they do have some concerns. However, ultimately we need to assess the overall benefit and that the amendments put and future management processes proposed will sufficiently address these. In closing, I thank the departments, agencies and committees on both bills, and to my fellow committee members for their work in the complex arena of biodiscovery in a short time frame. I thank the submitters to that bill and reassure them that their voices have been heard. To our traditional owners and custodians of the land, thank you for your reassurance at the hearing that concerns surrounding obtaining agreements between groups can be resolved through discussion. This is vital, as it is imperative that life-saving knowledge is not delayed or withheld from our communities through the inability to obtain agreements between each other or through red, green or any coloured tape. Thank you.
Thank you, Member for Noosa. I call the member for South Brisbane.
Thank you,